Judicial Precedent. Introduction. This topic is tested every year in Paper 1, if not, it will be assessed in Paper 2, where you will have to use the cases and match the facts with the current scenario to analyze and back your judgment. Judicial precedent relates to the source of law in which past judges' judgments create laws to be followed by future courts. It is also known as the case law. It is both historically and today one of the main sources of law. The judges use these cases to compare the facts of the current case and the previous cases to provide judgments. The Doctrine of Precedent. The English precedent is based on the Latin principle of stare decisis et non quieta movere, usually simplified to stare decisis. This means stand by what has been decided and don't dispute the existing. It supports the idea of justice, which upholds the certainty in the law. You can remember this as stare decisis, stand by what has been decided. Ratio decidendi. This is the actual and the central part of the judgment. It is binding. Precedent can only function if the legal explanations behind past decisions are established, so there will be a verdict at the end of a trial. The verdict will have two things, the ratio and the Abaddar statement. The ratio is the law for the verdict, while the Abaddar will be the reasoning behind it. In a verdict, the judge is likely to give a review of the ratio of the matter, examine the arguments put forward in the case by the proponents, and then clarify the principles of law that he uses to make the conclusion. Those principles are the essential factor in the decision and are known as the decision-making rule. They are the foundation of the decision. This is what sets the standard for judges to follow in future cases. Sir Rupert Cross defined the ratio decidendi as any rule explicitly or implicitly regarded by the judge as a necessary step in reaching his conclusion. Abaddar Dicta. These are the other things that a judge might say in a trial. However, they are not as crucial as a ratio. These can be used as persuasive precedent. They are not binding. The rest of the decision is called Abaddar Dicta, other things said, so courts will not have to enforce it in future cases. A judge will sometimes focus on what would have been his opinion if the facts of the case were different. This hypothetical example is something known as the Abaddar Dicta, and the legal rationale may be seen in future cases. However, it's not a binding precedent, as with all Abaddar declarations. A major issue when looking at a previous judgment is to separate the decision-making ratio from the Abaddar Dicta. This is because as the analysis is generally in a continuous form, with no headings defining what is meant to be part of the decision-making ratio and what is not. Judgments. It is also important to note that, based on the number of justices reviewing the case, there may be more than one statement after a trial. There will be only one judge in first instance trials and thus one decision. Nonetheless, at least two and generally three judges take cases in the appellate courts, the divisional courts, the Court of Appeal, and the Supreme Court. In reality, in the Supreme Court, there must be an odd number of judges in the court, which could be 3, 5, 7, or even 9. If there are two or more justices does not indicate that there are always multiple judgments because it is very common for one judge to give the judgment and the other judge/judges merely saying I agree. Nevertheless, more than one judge may want to clarify his rationale on the issue of situations where there is an especially important or complex point of law. For future cases, this may create problems since each judge may have had a myriad of reasons for their judgment. So there will be more than one decision-making factor, hence, more ratios than one. The plural of the ratio is rations. Some English phrases are important for understanding the definition of legal precedent as well as studying the Latin phrases ratio decidendi, Abaddar Dicta, and stare decisis. There should be a majority of judges agreeing on one decision for it to pass. Original precedent. When the case comes to the court for the first time, it has never been raised as an issue before. Remember the case of R.V.R., marital rape, and it is the main case. If the point of law has not been determined before in a court, so whatever the judge decides, there will be a new precedent for upcoming, similar cases to adopt, i.e., it is an original precedent. Since there are no previous cases on which the judge may focus his judgment, he is likely to look for situations that are in theory nearest to the case and might continue to use similar rules. One such case is R.V.R., where a wife sued her husband for marital rape. While there has been no previous precedent for marital rape, there was an original precedent for it. A case on marital rape has never come to the court earlier. In this case, it was decided that a woman can be raped by her husband, and the husband was considered guilty. In contrast, this method of making a conclusion is called reasoning. Many legal experts used to say that the judge simply applies what the rule is, i.e., the statute is always there, but it's the first instance a judge has had to determine which law to apply. This perception maintains that judges are not making law, they are simply stating what it has always been. It is now recognized that judges do have a regulatory position in these cases. The judge creates new legislation when a new point has to be determined. Hunter and others v. Canary Wharf Ltd. and London Docklands Development Company, 1995, can see this idea to create new law by comparison. Part of the decision was whether a broad buildings conflict with TV coverage could be an actionable private nuisance. The details of the case were that the first claimant in an industrial field in East London constructed a tower known as the Canary Wharf Tower in 1990. The tower was about 250 meters high and more than 50 meters high. The plaintiff, and dozens of others trying to sue her, claimed the first defendant's damages for interference over several years in receiving television broadcasts at their East London homes. The tower reportedly induced the damage. Binding precedent. It is decided by the higher courts, vertical hierarchy, or the court of the same level, horizontal hierarchy, hence, binding on the lower court and the courts of the same hierarchy. It is the precedent from old cases to be preceded even if the court does not agree with the legal doctrine in the latter case. Only when the facts of the second case are closely similar to the original case, then it is a binding precedent produced. This means that the decision was taken by a court that is senior to, or, in some cases, the same level, the court hearing the latter case. Hence, the judgment of the higher court is binding upon the lower courts. Persuasive precedent. Not binding but may be used. Lawyers can use this to argue their cases. If no case of such an issue can be found in the percent of the English legal system, cases from the USA, Shui v. USA, Australia and the other parts of the world can be used. Abaddar can also be used as a persuasive precedent. This is a precedent, i.e., not binding on the court. Still, it can be considered and decided by the judge that it is the right principle, so he is convinced that it should be followed. Persuasive precedent, as described below, comes from several sources. Courts lower in the hierarchy. Such an example can be seen in our v.R. 1991, where the House of Lords accepted and applied the same logic as the Court of Appeal when it ruled that a man might be guilty of raping his wife. Rulings of the Judicial Committee of the Privy Council. This committee is not a member of the England and Wales judicial system, and therefore its rulings are not final. Still, since many of its justices are also representatives of the Supreme Court, their opinions are treated with respect and can often be enforced. The law on the remoteness of damages in the law of torture and the decision taken by the Privy Council in the case of the Wagon Mound, No. 1, 1961, are an example of this. In this scenario, various cases in England and Wales upheld the judgment. This was seen in AG for Jersey v. Holly, 2005, when the majority of the Privy Council, 6 out of 9 judges, decided that a suspect should be measured by the criterion of an individual of ordinary self-control abilities in the protection of aggression. This was contradictory to the House of Lords' previous decision. As a consequence, the House of Lords and the Privy Council have made contradictory actions. Although a Privy Council ruling is not obligatory or binding on English courts, the Court of Appeal supported Holly in R v. Mohammed, 2005, instead of the House of Lords' judgment. Instead, in R v. James, R v. Karimi, 2006, a 5-member Court of Appeal decided that courts in England and Wales will obey the ruling in Holly. Statements made Abaddar dicta, particularly where the comment was made in a Supreme Court or previously a House of Lords decision. This is also seen in the ruling on intimidation as a shield against a criminal charge, where the House of Lords found in R v. Howe, 1987, that violence could not be a defense against a murder charge. The House of Lords has reflected in the judgment as an Abaddar argument that coercion would not be necessary as a defense to someone convicted of attempted assassination. When a man convicted of attempted murder tried to argue later in R v. Gotts, 1992, that he could use the protection of duress, Howe's Abaddar argument was adopted by the Court of Appeal as a persuasive precedent. A dissenting judgment, where the minority of judges decide something. Where a decision has been determined by a majority of judges, for example, 2-1 at the Court of Appeal, his arguments will be clarified by the judge who disagreed. If that appeal goes to the Supreme Court, or if there is a subsequent case to the Supreme Court on the same issue, the Supreme Court may choose the opposing decision and decide the case in the same way. We were convinced by the opposing opinion to obey it. Decisions of courts in other countries. This is particularly the case where the other nation is using the same common law concepts as in the UK. It applies to countries of the UK such as Britain, Australia, and New Zealand.